It's Michael Popok, Legal AF After Dark. You like lawyers who know what they're talking about law, politics, and justice? You're going to love Legal AF, our podcast in the MeidasTouch network. Here's a clip of our most recent episode where we catch you up with everything going on in the federal D.C. election interference case presided over Judge Chutkan, with the D.C. Court of Appeals hovering just over the top on issues of immunity and gag order against Donald Trump. Is that case still going to trial in March? Why has it been stayed? What's Judge Chutkan doing? And what happened to the gag order? And what about the U.S. Supreme Court? Are they going to get involved in the issue of immunity? All good questions to which we provide the answers on this clip. Take a listen. Let's talk about, because it's on everybody's front burner, we're getting decisions left and right from the U.S. Supreme Court, the D.C. Court of Appeals. We got a ruling just before we got on the air. I'll tell everybody later why I'm laughing. We have a sidebar chat among Salty, me, and Karen while we're doing the live, and he wrote something funny, which I will share at the appropriate time. Okay, now let me frame it and turn it right back over to my illustrious partner, Karen Friedman Agnifilo. We worried, and there was some misreporting earlier in the week, that the computer-generated order that spit out a appellate or an appeal schedule for Donald Trump's appeal of Judge Chutkan's ruling a couple of weeks ago, finding that he had no presidential immunity to dismiss the indictment in Jack Smith's D.C. election interference case. He took that up on appeal. Okay, no surprise there. So far, so good. Everybody's following along. And we expected that appeal. We also expected that at the appropriate point, that Jack Smith, if the Court of Appeals didn't do the right thing and kind of expedite it on their own, he would file some sort of paper somewhere, and maybe in multiple places, to expedite the appeal, to put it on a fast track, because we got a March 4th trial date. And we know that Donald Trump is just trying to burn the time, right? Burn the candle at both ends between now and March 4th to avoid the trial, right? He wants to push this out and kick this can so far past November that the voters have voted. That's exactly the opposite of what the public demands, what justice demands, which is that the voters know when they go to the polls. Are they voting for a convicted criminal or one that got exonerated and acquitted? Who knows? We don't know yet. That's the beauty of our justice system. I mean, I can hazard a guess what's going to happen at a jury trial, but that's just my speculation. And so when the first order came out, like, zzz, that's my printer noise, everyone was like, oh, crap. They're going to require the appeal not even get started until late December. It's too late. Donald Trump has won. All hope is lost. And people on Legal AF like me, you, and Ben were like, all right, relax. There's no panel yet. The 3-judge panel hasn't even been selected. They're the ones that make decisions on the briefing schedule, not the clerk or not the clerk's computer. And let's wait to see what happens. And if they don't form on their own, then I assure you, as I said on Legal AF recently, Jack Smith will file a piece of paper to make it happen. So he filed 2 pieces of paper, his office. One with the D.C. Court of Appeals, which is the intermediate appellate court that sits over Judge Chutkan's bosses in the District of Columbia. And they also filed a paper with the U.S. Supreme Court, hoping that one or both of them would bite. And both of them bit. The D.C. Court of Appeals said, this is a very interesting issue now that we have 3 judges in place. And I'll let you, Karen, comment on the judges. It's a great panel. Great for democracy, not terrible for Donald Trump in terms of who's been selected. And at the same time, they said, this is really interesting. Let's hear from the parties as to whether there should be expedited briefing on this faster than normal being 6 to 8 months to a year. Obviously, we need faster to keep the trial date, and tell us why. And then we'll make a ruling. And then at almost the same time, on the same day, the U.S. Supreme Court said, this is very interesting. Your request to have the U.S. Supreme Court be the first court of appeal, let us decide on original jurisdiction right now, without going through a lower intermediary court. It's unusual. We get where you're going with this, special counsel. We'd like to have that briefed. So we got simultaneous briefing going on a very close calendar here, very fast track. Tell us at the U.S. Supreme Court level why we, in the 9 people in black robes, why we should make this decision firsthand without having the benefit of a lower intermediary appellate court. And the appellate court going, let's hear the briefing on the expedited appeal, which closed today with a final brief by Donald Trump, citing Grinch That Stole Christmas, HarperCollins, 1957. I'm not kidding. On their brief, they wasted ink on that and said that was one of the reasons they couldn't have this case go so fast, because Jack Smith was a big fat Grinch. And within hours, the appellate court ruled. The DC Court of Appeals ruled. And I'm going to let you take it from there. What happened with the DC Court of Appeals? What's happening with the US Supreme Court next on these 2 parallel worlds of appeal related to whether Donald Trump is ultimately going to be able to use immunity of some sort to dismiss his indictment?
Yeah, so the DC Circuit Court of Appeals granted the expedited briefing, essentially. And so everything's due in December with the appellant's brief is due late December. The appellee's brief is due December 30th and the reply brief January 2nd. And then they'll talk about when oral arguments is, and hopefully it'll be done very, very quickly. But let's think of this kind of, I like the way you were talking about this and how you were explaining what's going on and really what the stakes of this are. And I want to just really simplify it for people so that they understand why this is so critical. The big issue here is presidential immunity, okay? And what he's saying is, because I was president at the time and I was doing my job as president, I should be immune if I got it wrong, like that's essentially what it is. If I make a mistake or whatever, I should be free when I do my job to make tough decisions. And therefore I shouldn't have to worry about watching my back because I could either get sued or get prosecuted. And that's really what he's saying. And there is a presidential immunity in the civil context. And because of that, right? Because of that, if you're acting as president within your job or within the outer boundary of what could be your job, we're going to stretch those limits a little bit because we want you as president to act freely and not worry about whether or not someone could sue you or would sue you. And that's what the civil presidential immunity is. But the question about, is there criminal presidential immunity? And I think ultimately the Supreme Court is going to have to rule that there is not. It makes no sense that there would be. Otherwise, just think of all the things one could do as a president and never have to be held accountable. It would fly in the face of everything this country stands for. But it's never been ruled on before. So as a result, it is something that is going to have to be ruled on. But let's just have a little academic exercise. If he is immune from prosecution criminally, then this case goes away 100%. If he's not, then the case proceeds. So this is truly foundational, right? Foundational. It's whether or not the case can go. And that's why he is permitted to appeal midstream while the trial's going on. He doesn't have to wait until after he's convicted or if he's convicted to appeal the way you typically do with most appellate arguments. And so what Donald Trump is doing, because this is so foundational, right? What he's doing here, and this is why this is such a critical, important juncture that we're at. His long game, his chess game is don't go to trial. Don't let anyone see what the evidence is. Don't get convicted. Get elected, right? In November, get elected, become president, and install my own Department of Justice head, the Attorney General, who will dismiss the case, and I'll pardon myself. Period. Full stop. It's terrifying what is at stake here, okay? And if this case doesn't go in March, because we're still waiting on the appellate courts to determine this foundational question, what will happen in March? Then March 24th comes around, and Alvin Bragg, the Manhattan District Attorney, his case will be on the calendar in front of Judge Juan Merchan, and they'll come to court, and the prosecutor will say my 3 favorite words: the people are ready. And that means the people are ready for trial. And in New York, we say the people. In federal court, we say the government. So that will go to trial March 24th. And because that's going to go, and so for all the people who are like, why this case? Why did he bring this case? Why is this the first case? This might be the only case. We are all going to look back and say, you know what? Thank God for Alvin Bragg and this case, because that might be the only case we see that holds him accountable, because we all know that Eileen Cannon has no desire to bring her case in May. Right. But she's not going to also say, hey, you know what? Let's put it off, even though we know that's what she's going to do. And so if this Judge Chutkan case doesn't go forward in March, on March 4th, the way she was trying to get it to do, she won't be able to put it into May, because that's where Judge Eileen Cannon is, right? And so it would get pushed to what, June, July, and then it gets so close to the election, and then it becomes really complicated, and it can't go before the election. And so, because there's no way you're going to have a criminal trial right in the heat and heart of a presidential election. And so this is really, really important. And what's happening right now is Jack Smith is basically saying to the Supreme Court and to the DC Circuit in parallel, which is unusual, so highly unusual. The way it always goes in 99 out of 100 times is you go to the district court, you go to the appellate court, and then you go to the Supreme Court. That's the way it always is. There's been, I think, 45 or 50 times in our lifetime that was reported this week where the Supreme Court allowed them to leapfrog the middle portion of this, right, the circuit, and go straight to the Supreme Court. And since 2019, the Supreme Court has done it many times. I think it was almost a dozen or 24 times have allowed that to happen in some really foundational, fundamental cases that have been faced, that they've been faced with. So they do this, unlike, in the past where this wasn't ever done. This current Supreme Court does this. And so hopefully they'll take it quickly and keep the March 4th date, because if it doesn't go March 4th, I would venture to say it's likely to not go before the election. And then, I just played out the long game that Trump is looking to play. So this is extremely, extremely difficult, and this is extremely important. And so I want everyone to just really understand what is at stake here.
Okay, let me be the devil's advocate on a couple of those points, because I got to hold up my end of the conversation. First, I think the DC Court of Appeals, I think the Supreme Court's going to back out and let the DC Court of Appeals make the initial ruling. I think that ruling is going to come based on the briefing schedule that they've set, or going to set, is going to come very, very quickly. I think they are going to be working over Christmas, despite Donald Trump's citation to the Grinch that stole Christmas as one of the reasons why they shouldn't be forced to work over their Christmas holiday. Here's the quote on page 13. I'm not making this up, everybody. They wasted valuable ink in one of their key arguments to cite to Dr. Seuss. What comes next? Hop on Pop? Green eggs and ham? I mean, they're just exhausted intellectually, and this is what you're left with. They led in that brief, just so you know. This is why it only took the appellate court hours to decide. They were like, let's see what Donald Trump has to say. First paragraph in Donald Trump's brief was, this is a partisan attack by Joe Biden over the #1 person who will beat him in November. Okay. And the appellate court was probably like, okay, can we get to the point as to why there's not a substantial public interest in having this appeal and the decision on your immunity that you've raised yourself, and the fact that you've asked for expedited appeal and got it for the gag order? Why we shouldn't grant expedited appeal, especially since there's some precedent that I think is pretty close to being on all fours, which has to do with the Watergate days, in which they asked the DC Court of Appeals during the Watergate times to hurry up and rule on immunity and other executive privileges so they could get the Watergate trial started. Sort of on point. And so the panel took one look and said, what else has he got? And they looked at the brief and they said, no, that case doesn't apply. And the argument about there's a primary coming up and Super Tuesday and Donald Trump there's a First Amendment right for the public that likes Donald Trump to hear what he has to say. We're not talking about a gag order anymore. We're talking about, and I also thought it was insulting, and I said this in a hot take. I thought it was insulting to the 3-judge panel that's been picked to imply or to actually say that you're too stupid to make a decision quickly based on full briefing, and you should give a more you need more time. You've got to be more deliberate. Okay, this is an appellate court at the highest level. This is like the major leagues of courts of appeal. This is their job. This is what they get paid to do. Fast, slow, normal track, fast track. They read briefs, they conduct oral arguments, they do the legal analysis, and they make a ruling. Doesn't matter if it's a week, it's a month, it's 6 months, or a year. And so to insult them and say, you need more time. So they love this argument. Give judges more time. It's not that they want to give the judges more time. It's as you said, Karen, they want to just burn more time off the clock because they want to get closer to and burn through March. And so I think the Supreme Court backs out. The Court of Appeals on fast briefing, I think ultimately rules that he is beyond the outer boundaries of any argument of immunity here. And they do not dismiss the indictment, because that's the question. How do you dismiss an indictment? And so, yes, Judge Chutkan just today, see, we had a lot of things happen just today, ruled that she agreed with both sides. Both the Department of Justice and Donald Trump said to Judge Chutkan, while this appellate issue is in place, you must stop and not do anything else in this trial. Don't decide anything else. I mean, the Department of Justice was a little bit different. There's a couple of things you can still decide, but anything that deals with immunity, you got to stop. You got to just put a pin in the trial. And she's done that, just so everybody knows. As of right now, as of this time, at 8:21, p.m. Eastern time, there is no further activity in the trial to prepare for trial. I mean, Jack Smith's team can prepare for trial, but in terms of her making decisions, rulings, there's still motions that are pending. All stops, which then gives additional weight and credence to the decision by the DC Court of Appeals to do this quickly, because they don't want it to stop. Remember, this might be news to people just joining. Last week, another 3-judge panel of the Court of Appeals, buried on page 47 of their decision about the gag order, re-gagging Donald Trump, basically implored their colleagues on this panel, the current Court of Appeals, not to delay the trial, do everything they could to get the trial back on track. That was like a voice. They were sending a message. They rather just pass them in the hallway or at the cafeteria. They wrote it in their opinion last week. And so the Court of Appeals, I think, is taking this very seriously in the historic moment of it. Now, let me just talk briefly about the date in March, May, and self-pardon. Just to throw it out there.
Can I add one more thing for you to also say?
Sure.
I want you to also weigh in on whether this will stay. If, let's say, Fani Willis sees the writing on the wall and says, oh, let's move up my trial. Do you think the supremacy clause will require a stay of her case as well, given that it's the same subject matter? So I just want to add that to your list of things to comment on, please.
Yeah, thank you. It's like speed chess. Okay, go. I'll do that one last. On the March, May issue, I think if she needs another month to get her trial going, Judge Chutkan, under the judicial canon, she can pick up the phone and call Judge Aileen, I think it's pronounced, Aileen Cannon, and Judge Chutkan can say, hey, Aileen, I need to move my trial ahead. You've been this is my paraphrase. You've been jerking around with the Mar-a-Lago thing long enough. Time to, or get off the pot. Are you taking the trial date in May, or I'm going to take my April date? So there is a dialogue, same dialogue that went on between Judge Chutkan's chambers and the chambers of Judge Merchan up in New York for the Stormy Daniels case that you talked about. And Judge Merchan said, I'll step aside if you need me to. All right. And then before I get to the Georgia thing, this issue is not clear, because no president in our republic has ever tried it, to pardon themselves. Now, I don't think it gets to pardoning themselves. I think Donald Trump pulls the plug on the Department of Justice if he can. Now, if a special counsel is appointed, it's a little trickier under the special counsel law. That's why Bill Barr raced to put that the guy in place, John, what's his last name? It'll come to me. Somebody help. The special counsel looking at all things related to Salty saying which case, I'll get it. It's a special counsel that Barr put in place to protect him from being dismissed by Joe Biden and by Merrick Garland to go after whether, the Russia hoax and all of that. And so there are protections within the independent
John
counsel.
Durham?
John Durham. I was going to say Raleigh. I knew it was in North Carolina. I'm
like, he can't mean Mueller. So
no. Durham.
John
You're so
Durham.
right. So right. And so there are protective measures within the independent counsel rule, which I'm not sure it's that easy to get rid of the special counsel, even with a new, sycophant friendly, Donald Trump friendly attorney general. But we'll see that. But that's what he'll try to do. Surely you're right about that. He will try to gut the Department of Justice, hollow out, cut off resources, and not allow that case to go forward if it's not complete. And then we'll have to debate the issue of whether he has the ability to pardon himself. And then what happens if he tries to? Of course, that'll go up to the Supreme Court in various ways, and we'll see what they may not even like that, like self-pardoning for crimes that have been convicted. So we'll see. As to Georgia, you raise a very interesting issue, and I've seen various debates about it. I know that Trump's lawyers think the Supremacy Clause applies. I know Trump's lawyers, like Steve Sadow, has said in court that he thinks the Supremacy Clause would eventually bar or ban this. I'm not sure about that, and I'm not sure there's a complete.
Explain to people what the Supremacy Clause is, just in case they don't know what it is.
Well, I mean, where there is an overlap between subject matter and the federal in our federalist system of states and federal government, the federal government can oust the state, and in this case of justice, criminal justice, can, as you said, make them stop their state case because they have a federal case overlapping subject matter on the same. There's going to be a fight over whether it's overlapping subject matter. There's going to be a fight over whether the indictment can be narrowed, for instance, for Fani Willis to do less, because they, even though there is obviously overlap between the two. Well, so that's the way that shakes out. McAfee hasn't ruled on that in Georgia. It hasn't been brought to anybody's attention. We'll talk about whether there's waiver related to that. When do you bring the Supremacy Clause up? How far along do you have to be? We're pretty far along in Georgia here. Like that, you're going to love what we do every week, twice a week on the MeidasTouch Network on Legal AF. It is what you think. It's every Wednesday and Saturday at 8 p.m. Eastern Time. And we pull together and curate stories just like that, do about 4 or 5 at that intersection of law, politics, and justice, and bring it to you just that way. So if you know what I'm talking about, welcome back. And welcome to Legal AF. If you have no idea who I am or what I'm talking about, I'm Michael Popok. That's Legal AF. And we'll see you on our next podcast. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.